Good morning and welcome. It is 10 o'clock on Tuesday, June 13th, 2023, and I call to order the Kansas Corporation Commission business meeting. I'm Susan Duffy. I serve as chair for the commission, and I'm joined by Commissioner Keene and Commissioner French. Today on our agenda, we have 15 consent items and 5 noticed items and 1 discussion item. Commissioners, you've had the opportunity to review and study the consent agenda. Are there any questions or comments? And I'll start with Commissioner French.
No questions, thank you.
And Commissioner Keene.
No questions. I would move approval of the consent agenda.
I will second the motion.
There is a motion and a second to approve the consent agenda. All those in favor, please vote aye.
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 Aye, the motion passes. Thank you. Our first noticed item is docket number 19GBEE253ACQ. This is in the matter of the joint application of Invenergy Transmission LLC, Invenergy Investment Company LLC, Clean Line Energy Partners LLC, Grain Belt Express Clean Line LLC, and Grain Belt Express Holding LLC for an order approving the acquisition by Invenergy Transmission LLC of Grain Belt Express Clean Line LLC. This is an order on motion to amend the unanimous settlement agreement. And as you all recall, it was on last Tuesday's agenda, and we did have some questions and it was pulled until today. Our presenter is Mr. Brian Fedotin. Good morning, Mr. Fedotin.
Good morning, commissioners. The Grain Belt Express project is an approximately 780-mile transmission line that will connect over 4,000 megawatts of low-cost wind power in western Kansas to customers in Missouri, Illinois, Indiana, and states farther east. On June 18th, 2019, the commission approved the unanimous settlement, finding that it was in the public interest. On March 10th of this year, Grain Belt Express filed a motion to amend the unanimous settlement for purposes of amending the financing requirement, which would allow benefits to accrue in Kansas earlier. Currently, paragraph 9A bars Grain Belt from installing transmission facilities on easement property in Kansas until it's obtained commitments for funds to build the entirety of the line. But now Grain Belt has plans to construct the project in 2 phases, with Kansas being in the first phase, and therefore wants to modify the financing agreement to allow it to install transmission facilities on easement properties in Kansas as soon as it obtains commitments for funds to build phase 1 of the project. On October 27th, commission staff filed a report and recommendation recommending approval of the motion to amend the unanimous settlement agreement. Staff's report and recommendation agrees with Grain Belt that the proposed amendment will not reduce existing protections provided to Kansas landowners, investors, or the public by the original agreement, or reduce the project's benefits to the state of Kansas. Staff believes that it is likely that constructing the project in 2 phases will bring benefits to Kansas earlier than it had the project been in 1 phase. To address some of the questions that Commissioner Keene raised at last week's open meeting, construction on phase 1 will not begin before Grain Belt receives approval from both this commission and the Missouri Commission. And also construction will not begin until each of the requirements of the amended financing requirement in paragraph 9 of the amended settlement agreement have been completed. Even if phase 2 never materializes, phase 1 will be operational and capable of moving wind from western Kansas east on a merchant line paid for by the subscribers, not by Kansas ratepayers. Approving the proposed revisions to the settlement agreement will not remove or alter any of the protections that Kansas landowners received in the original settlement agreement. In this order, the commission finds that amending paragraph 9A of the unanimous settlement is in the public interest. Therefore, this order grants the motion to amend the unanimous settlement agreement. I'm available for questions.
Thank you. Let me turn to commissioners for questions or comments, starting with Commissioner Keen.
Thank you. Just a few brief comments from me. We have to keep in mind, this is a merchant line. It's paid for by the subscribers and not by Kansas ratepayers. At my behest, this order was held over because I wanted to be able to, in a little greater depth, consider and address how, if at all, the revisions being sought to the settlement agreement would affect the protections to Kansas landowners that were included in the original settlement agreement. And so my understanding now is that the approval of the proposed revisions to the settlement agreement will not remove or alter any protections for Kansas landowners and that were established in the settlement agreement. I appreciate in the process of this clarification and of my concerns. I appreciate the efforts of staff generally and of Mr. Fedotin in particular. I appreciate also the indulgence of the commission in holding this over until today to consider the matter. Thank you.
Yes, and Commissioner French.
I have no questions. Move approval of the order.
Second.
There is a motion and a second to approve the order. All those in favor, please vote aye.
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 Aye, the motion passes. Thank you. Our next item is docket number 23 EKCE 665 TAR. In the matter of the application of Evergy Kansas Central Inc. and Evergy Kansas South Inc., both doing business as Evergy Kansas Central's updated transmission delivery charge TDC tariff. This is an order on transmission delivery charge. And again, our presenter is General Counsel Brian Fedotin.
Thank you. On April 11th, the commission issued an order acknowledging the effective date of transmission delivery charge subject to refund pursuant to KSA 66-1237, concluding Evergy Central's proposed TDC rates should become effective May 1st on a subject to refund basis while the commission conducts its review of Evergy Central's revised 2023 TDC. On May 19th, commission staff filed a report and recommendation recommending approval of Evergy's requested TDC revenue amount of $287,761,232, which would decrease the average residential monthly bill by $1.62. The commission agrees with staff's conclusions that Evergy Central's TDC filing accurately reflects the nature of the costs incurred from the Southwest Power Pool on behalf of its retail customers to provide transmission service, and that Evergy Central's TDC charges were calculated correctly. Thus, the requested TDC amount is approved, and again, that should decrease the average Evergy Central residential customer's monthly bill by $1.62. And the order notes that in April, the governor signed House Bill 2225, which amends KSA 66-1237 and will reduce the return on equity portion of the TDC, but that doesn't take effect till July 1st, and therefore any resulting calculations in ROE will be made to the 2024 TDC filing. With that, I'm available for questions.
Thank you. And I turn to Commissioner French for questions or comments.
No questions.
And Commissioner Keen.
Just one brief comment. Thank you for the overview, Brian. I think that was very helpful. I appreciate also the fact that you alluded to the fact that 2023 House Bill 2225, there's a lot of twos in there, which was signed by the governor and approved by the legislature, obviously, will take effect on July 1st of 2023 and will have an impact henceforth on the calculation of these TDC charges. This allays a major concern that I had under the prior law in terms of the ability of the commission to review or have any impact over the whole process of the TDC. So with that having been said, I certainly intend to support this. And with that in mind, I would move approval of the order.
I'll second the motion.
We have a motion and a second to approve the order. I would just add that when that legislation was implemented, I believe way back in 2014, that there was a reason that was put into place, and it was to maybe incent some transmission building. The parties believe, or our staff and legislature and the governor, that that's been accomplished. And so that this legislation puts the onus of review and actual, more than just a review, but the ability to affect the numbers back with the commission. So with a motion and a second to approve, all those in favor, please vote aye.
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 Aye, the motion passes. Thank you. Our third item, and the matter, docket number 23 EKME 666 TAR, and the matter of the application of Evergy Kansas Metro Inc. filing its annual transmission delivery charge. And this is an order on the transmission delivery charge. Again, our presenter, Mr. Brian Fedotin.
Yes, thank you. The order that I just presented and that was just approved, the 665 order, was for the Legacy Westar portion of Evergy. This docket 666 is for the Legacy KCP&L portion of Evergy, and it's kind of the companion docket of the 665 docket we just approved. With that, much of the language that we just discussed is it in the prior docket is in this order, but I'm going to skip that for the presentation, try to keep a couple viewers awake. The difference here is staff's report and recommendation recommended approving Evergy Kansas Metro's requested TDC revenue amount, but it's a different amount than what we had in the last docket. The TDC revenue amount for the old KCP&L is $47,329,103, which would increase the average residential monthly bill by 75 cents. This order approves the requested TDC revenue amount, which again, like I said, will increase the average Evergy Kansas Metro residential customer bill by 75 cents a month. It has the same language about House Bill 2225, noting that any resulting ROE calculations will be made in the 2024 TDC filing. With that, I'm available for questions.
Thank you. Turning to commissioners, Commissioner King, do you have comments or questions?
One very brief comment. As Brian alluded to, this is basically the Evergy Metro copy, the AC carbon copy of the Evergy Central order. And in fact, the amounts are different, of course, but it's a similar approach here. Once again, here, Evergy Metro is also, their transmission and delivery charges are also impacted by the House Bill 2025 effective July 1st of 2023 and thenceforth. One thing I neglected to state in my comments under the previous order, which I'll rectify here, is I think that this bill was a product of our staff and some very fine staffing work that took place within the commission. And it also was a product also of input from a very diverse coalition of other parties that were interested in a similar result to that advanced by our staff. Having said that, that's the end of my comments. Thank you. Yes, that's it.
Okay, Commissioner French, comments or questions?
I have no questions. I move approval of the order.
Second.
There's a motion and a second to approve the order. All those in favor, please vote aye.
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 Aye, the motion passes. Thank you, Brian.
Thank you,
Our
Commissioners.
next item is docket number 23 TRAM 679 PEN. This is in the matter of the investigation of Gold Logistics LLC of Kansas City, Kansas, regarding the violation of the motor carrier safety statutes, rules, and regulations, and the commission's authority to impose penalties, sanctions, and/or the revocation of motor carrier authority. This is a penalty order, and our presenter today is litigation counsel, Hassan Latif. Good morning, Mr. Latif.
Good morning, Commissioners. I need the penalty order before you arises out of a compliance review of Gold Logistics LLC, a common carrier which hauls general freight operating out of Kansas City, Kansas. This investigation was conducted on March 20th by investigator Matt Adams. During staff's investigation, the special investigator found several violations, and the order before you assesses penalties for 8 of those violations, resulting in $5,750 in total penalties. The violations, I'll briefly summarize, included a $2,000 fine for permitting drivers to falsify records of duty status, a $1,000 fine for failing to provide supporting documents for the loads hauled, and additionally, there were violations related to the carrier's timekeeping and inspection records. Staff believes the order appropriately assesses penalties against the carrier and recommends approval of the order. Both I and staff are available to stand for questions.
Thank you. And I would note that Director Mike Hamey and Assistant Director Gary Davenport are available for questions. And I turn to Commissioner Keen.
A brief comment for me. Once again, safety is the order of the day here with regard to these field inspections that our transportation division staff conducts. I want to commend Field Inspector Matt Adams in this instance for his diligence and his thoroughness in conducting this investigation and trying to basically bring about in the process an enhancement in the safety, over the road safety. So my thanks to him.
Very good. Commissioner French, questions or comments, please?
I have no questions. I move approval of the order.
Second.
There is a motion and a second to approve the order. All those in favor, please vote aye.
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 Aye. The motion passes. Thank you. Our next item is docket number 23 DPAX 733 PEN. This is in the matter of Black Hills Energy Corporation of Wichita, Kansas, regarding the violation of the Kansas Underground Utility Damage Prevention Act, commonly known as CUDPA, and the Commission's authority to impose penalties and/or sanctions. This is a penalty order. And again, I turn to Hassan Latif for explanation.
Thank you. The penalty order before you assesses a fine of $9,000 to Black Hills Energy, a natural gas public utility, for violations of the CUDPA statutes. This order is included as notice item today because of the size of the penalty being assessed. The penalty order compiles multiple violations alleged between December 2021 and December 2022. In that time period, there were 9 instances where the company failed to provide excavators with the location of buried facilities before excavation began. The order assesses a penalty of $1,000 for each violation, totaling $9,000. According to staff's R&R, there have been 42 notices of probable noncompliance issued to Black Hills Energy dating back to 2020. And in the present order, the 9 alleged violations did result in damage to natural gas lines. Black Hills Energy responded to staff regarding each violation, stating that they were results of failures by either the company's own staff or its contract locator. And the company has restated its expectations to its personnel and contractors regarding following the procedures of the CUDPA to prevent these types of violations in the future. Staff believes this order appropriately assesses penalties against the company and recommends approval of the order. Both I and staff, again, are available to stand for questions.
Thank you. And I would note that we have the Director of Gas Pipeline Safety, Mr. Leo Hanos, here. Thank you, Leo. I'll turn to Commissioner French for questions or comments.
I have no questions. Thank you.
And Commissioner Keen.
I do have a question. Um, Black Hills is a very credible entity. Leo, my question to you would be this: given the repetition of these kinds of violations, to what would you ascribe that? And are you of the belief that the company is taking proactive actions to try to preclude a reoccurrence?
Yes, in this case, I believe they are taking the right actions. Looking through the attachments to the penalty order, you'll see their responses. They're well thought out. Some of these were due to legacy piping where maps were not available. Others were because of the unique situation that Wichita finds itself in, where there's a blended set of facilities, and namely that KGS and Black Hills have pipelines on the same street. And that has led to a couple of damages. And then others were just some locator errors from their contract locator. Overall, it was about 50-50 on both the locator side and the company side. 9 is any damage is a near miss that you could have an accident, especially with natural gas. But 9 is not a really large number that we're seeing here as far as ones that we felt were worthy of a penalty.
Thank you very much for that perspective and explanation. I would move approval of the order.
Second.
We have a motion and a second to approve the order. All those in favor, please vote aye.
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 Aye, the motion passes. Thank you.
Thank you.
Our last item is a discussion item, and this is the Federal Energy Regulatory matter. Federal Energy Regulatory Commission, or commonly known as FERC matter, and docket number RP 22-1033-000. And today our presenter is Carly Messentine. She's our senior litigation counsel. Carly, good morning.
Yes, good morning. On May 12th, 2023, Northern Natural Gas Company, or just Northern, FERC trial staff, and the customer group reached a settlement agreement in principle that resolves all of the outstanding issues of its Section 4 rate proceeding filed at the Federal Energy Regulatory Commission, or FERC, in docket number RP-22-1033. The settlement agreement is a black box agreement proposing to implement stated settlement rates, which produce approximately $1 billion of revenue based on the filed billing determinants in Northern's application. In total, Northern's cost of service has increased by $150 million over its previously approved cost of service, which was $860 million in FERC docket number RP 19-1353. Now, the primary driver of the rate increase here is from Northern's investment to modernize its pipeline infrastructure and other capital maintenance investment, which results in a rate base increase of about $1.1 billion from December 31st, 2019. The settlement agreement includes a rate moratorium as well that extends through June 30th, 2024. The settlement agreement distinguishes settling parties into two separate categories. Listed in Appendix A are parties who support the settlement agreement, and listed in Appendix B are parties not opposed to the settlement. Based on staff's participation in the rate proceeding and the settlement process, staff recommends the Commission authorize our DC counsel to represent our non-opposition to the settlement agreement and to identify the Commission as a party in Appendix B.
Very good, thank you. I'm going to turn to Commissioner French for questions or comments on this matter.
I have no questions. Thank you very much for the presentation, Carly.
Okay, Commissioner King, do you have questions?
I have no questions, and as well, I thank Carly for the presentation.
Yes, this has been a long-going matter before FERC, and back and forth between the parties, as well as it should, as Northern Natural is the largest gas company in the United States. I do appreciate our staff's involvement and our DC counsel as well in this matter. As such, I move the commission authorize our DC council to represent that the commission does not oppose the stipulation and agreement in FERC docket number RP 2210330000 and include the commission as a non-opposing party in Appendix B. Do I have a second? Commissioner
I'll
Key?
second.
Commissioner French, thank you. So there's a motion and a second. All those in favor, please vote aye.
Aye.
Aye, the motion passes. Thank you. I appreciate your presentation, Carly.
Thank you.
Commissioners, I believe that does conclude our agenda today. Are there any other matters to come before the commission? Turning to Commissioner Keen
None for me, thank you. I would move that we adjourn.
and
Second.
Commissioner French, second. All those in favor, please vote aye.
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 Aye, the motion passes. We're adjourned. Everyone be well, be safe.
Take care.